Separated and can't afford your mortgage? Worried about what to do with your family home during the divorce? In this video, we'll explain 4 practical options to help you navigate this challenging situation. Entitlement to the family home. You may be wondering, am I entitled to half the house if I'm not on the mortgage? Well, the good news is that even if your name isn't on the deeds of the mortgage, you might still be entitled to a share of the family home. In legal terms, the person not named on the deeds or mortgage will need to prove a beneficial interest in the property. This can be demonstrated by contributing to joint finances, paying the mortgage, or taking care of ongoing property maintenance. However, it's important to consider the length of your marriage, as especially short marriages may not always result in property entitlement. Seek professional advice to understand your specific situation. Options for dealing with the family home. So, what happens when you separate and have a mortgage? Let's explore the 4 main ways to deal with the family home during a divorce. Option 1. Sell the property and split the sale proceeds in a way you agree is fair. This may require negotiation through mediation or a decision by a judge in court. The money received can be used for new accommodations like rentals or purchasing a new property. Option 2. One of you may choose to keep the family home by buying out the other person's share. This way, the property becomes solely owned by the person who bought out the share. Option 3. You can agree to keep the family home for a fixed period, allowing one person to continue living in it. This option may be suitable when considering the children's education and upbringing. Option 4. Transfer a share of the property ownership to one partner who doesn't live there anymore. They will receive a share of the property's value when it sells in the future. This option can be combined with the previous one. Mesher orders and Martin orders. In England and Wales, a Mesher order is a court order that defers the sale of the marital home till a later date. This can be used when one person will continue living in the home until a specific event, such as when their youngest child turns 18. On the other hand, a Martin order is a court order that prevents the sale of the property until the occupier passes away or remarries. This is typically used when the other person doesn't require the property sale proceeds for their standard of living. Keep in mind that processes may vary in Northern Ireland and Scotland, so it's important to understand the specific regulations in your jurisdiction. Mortgage responsibilities. Now you might be wondering, do I have to pay the mortgage if I get separated? The answer is yes. A separation doesn't affect your mortgage agreement, and if you're on the mortgage loan, you still have a joint liability to keep up with all mortgage payments until a resolution is reached regarding the property and mortgage. The possibility of a guarantor mortgage. But there's one more option we haven't revealed yet, a guarantor mortgage. A guarantor mortgage is when somebody else, like a family member or a close friend, offers to guarantee your mortgage payments or pay the shortfall if you can't afford it. This option can be particularly useful if you're divorcing on good terms, especially when children from the marriage will continue living in the home. Cost of divorce with property. Now let's talk about the cost of divorce when property is involved. It depends on various factors, but the main driver of increased costs is often a failure to negotiate effectively and reach an agreement on assets and finance division. If you can't come to an agreement, you may need to use mediation services, collaborative law, or even involve a judge. These additional steps can add delays and expenses to the divorce proceedings. Court application fees, mediation fees, and the need for divorce solicitor services can contribute to the overall cost. Separating on a low income. If you're on a low income and want to separate and get divorced, there are options available to you. Option 1. Consider a DIY divorce, which means not using legal services. However, be aware that this comes with risks, such as not receiving your entitled divorce settlement or leaving yourself open to future financial claims. Option 2. Check if you qualify for financial help. You may be eligible for assistance with court fees, mediation, and financial orders if you have a low income or receive state benefits. Option 3. Combine both options depending on your circumstances. Even with the most amicable of divorces, it can still be worthwhile to consult with a solicitor for expert advice on how to proceed. These days, there's many online solicitors that can work out cheaper and easier than meeting in person. JustAnswer, for example, only costs £5 for a trial, which could be far less than a traditional in-person appointment. One of my colleagues used their service and saved over £270 on a parking ticket. I've linked that offer in the description, and if you use that, you'll also be supporting Money Nerd, so thank you.